Hi, everyone. Harry here to talk about a Supreme Court opinion, decision, I guess you could call it that, in its laconic two-sentence form for the shadow docket that says Lisa Cook, a member of the Fed, whom Trump has tried to fire over what I think it's fair to say objectively are just bogus trumped up charges of mortgage fraud. The Supreme Court holds that they had held already that they're going to hear Cook's case saying you didn't have power to fire me. And then yesterday, they had received a emergency application from the administration, which so often has said remove the impediment or the stay that a district court has put on and let us go ahead and do our worst, possibly unconstitutional worst, until you decide the case. And the court has done that again and again and again. And it's had the practical effect of basically creating new law, as Justice Kagan most recently said in her really eloquent dissent. They're just creating new law with the shadow docket without briefs, without questions presented, without decisions. What I've read to you is everything we know from the Supreme Court from yesterday. Now, it does go against the administration. The administration says, in the meantime, let me fire Lisa Cook. And so, it's pretty cryptic, but is deferred pending oral argument in January 2026. So what that means is, whereas in case after case, we have said that, well, pending the time when we or others decide on the merits, the administration can do whatever the hell it wants. And that typically means the decision is just made. It's a fait accompli by the time, even if in the very unlikely event that the Supreme Court would rule for the plaintiff, because they're basically signaling they wouldn't by saying the administration is likely to win. That's one of the considerations or factors for granting a stay. Even if they were to change their mind by that time, if they let them oust Cook and put somebody else in, and then they decide, in a year, oh, she has a right to be there. It's, you can't unscramble the eggs. People understand that. And it means that, Cook, she's not going to walk back into what probably is already a body where she has been replaced. Okay. But this is a really interesting thing from the U.S. Supreme Court that seems inconsistent with with the sort of demolition job it's been undertaking in general on independent agencies, and perhaps a kind of admission that, like, Trump and this kind of power is a buffoon, and letting him do this to the Fed would just be too dangerous. It would pose the potential of just getting rid of everything that's been good about the Fed, imposing and replacing people with political lackeys who, among other things, are not just less independent, but less knowledgeable, and all the harm to domestic and international markets that could ensue. But it seems very inconsistent with what it's been doing. So let me recap briefly. You've heard this story now before. Generations of law students learn there are agencies or departments like Justice and Defense and Health and Human Services that are directly under the president, and the president just decides whether or not the president can fire the head of HHS tomorrow because he doesn't like the way his eyebrow goes up, or, probably not because of race, but almost any other reason. However, there have been, since the 30s, a whole collection of agencies. It's basically the alphabet soup that drove our recovery from the Great Depression and had really been the economic and social planners of our country since. Many different, FCC and FTC and FPB, the sort of whole alphabet soup. That's been the political story, basically, since the 30s. The government is very much, and in ways that hugely affect people, run by these agencies, as to whom Congress has said they need to be independent just a little. And what that means is you can't fire them, Mr. or Madam President, for any reason you happen to think of. You need a cause. They need to be doing something wrong. That's not, I'll just say as a sort of editorial aside, that's not like a huge hamstring on the president. That's the way it works in most places, right? It's just not right to fire people for no reason. You need a reason, and that's all it says. But that has, for many years, stuck in the craw of certain conservative thinkers who say it violates a kind of pristine structure of the Constitution. The Constitution has Article 1, Congress's powers are thus and so. Article 3, the court's powers are thus and so. And Article 2, which says, uniquely, the executive power of the United States shall be in a president of the United States, meaning all the executive power, meaning if executive, then the president controls, meaning to them that the effort by Congress to impose restrictions on when the president can fire people in these agencies that Congress, by the way, has created, is unconstitutional, because the executive power has to be in the president. These agencies, therefore, they are created by Congress as executive agencies. The president has to be able to fire them. So back to generations of law students who learned, there's a lot of folks that the president has complete authority over, just like almost any business. But there's a whole bunch of other really important agencies where there's some restriction and you just can't do it in a pell-mell way. And let me just say for a second, there is something ungainly or a little bit weird. You have, where are these agencies? Are they executive agencies? All the executive power is in the president. So why can Congress fetter him in this way? But the answer to it has been, we've long since crossed that Rubicon. This is how we do things here, same as other kinds of legal developments that could have been the other way, but that's where they are now. The Privileges and Immunities Clause of the 14th Amendment, kind of a dead letter because of one U.S. Supreme Court opinion that could have gone the other way, but this is the way it works now. And so that's been the kind of defense of people of the liberal state, which, as I say, has been effectuated in really important ways that are, totally impact on people's lives from the cradle. What the FDA and what formula provisions are, and on and on and on. This conservative court has little by little by little demolished these ideas. They've taken an agency at a time, and with various agencies, without questioning yet this basic precedent, Humphrey's executor, remember that says, makes the constitutional possibility of Congress being able to limit the executive to firing for cause. They've little by little said, this agency, you've got just a single head there. That's too much power. That's a violation of separation of powers. Goodbye. The president can do what he wants. That agency, okay, there are many people atop it. It's a multi-member board, but the kind of power they exercise, two down the middle and central executive power, you can't have Congress do, as it has tried to do, impose limits on the ability to discharge. Boom, there it goes, leaving two agencies standing. One is the very agency that was the subject of the landmark opinion in 1935, Humphrey's executor. That is the FTC. And the court has signaled very strongly, it's on the chopping block and it's gone. So basically, it including now the FTC, will have never met an independent agency that it likes, and will always strike it down. But now we come to the Fed. The Fed's independence is just the same as the independence of other agencies, meaning, Trump can't fire Powell unless he's got a good reason. That is actually the legal issue in play in the Cook case, is this mortgage fraud, which they think they're on to a good and they knew about from before, and she denies his mortgage fraud, etc. Is that a good reason to fire her under the extant statutory scheme that says you can do it for cause? But hovering in the background, everybody knows, is, what about the Fed? Every time you've looked at independent agencies, you struck them down and said you can't do that to the president. What are they doing with the Fed? They basically, and by the way, that includes these temporary grants of relief on the shadow docket, which has in effect disposed of the independence of agencies before the whole case has even been heard until now. And I don't think there's a stronger hypothesis than just the court realizes, it's an oh shit moment for the court. If we tell Trump he can fire whoever he wants, and he does, and he brings in bozos and the like, that's it for everybody's pension plan. He's incompetent and political and crass. And if you do here, as you've done in other agencies, make the single criterion of qualification be loyalty to Trump, you're talking about potential catastrophic impact on domestic markets, international markets, which the United States is obviously the most important factor for. Now, they're super important. Does that suggest any kind of principal distinction in the body of law the Supreme Court is assembling, basically striking down independent agency after independent agency? It doesn't. It doesn't. So this is what seems to me to be a patently inconsistent way of treating this really important area in the law. What they've done so far means, everything that's been good, and it really has been a very big success story, from vaccines to school standards, that these independent agencies have done great things. They're all gone now, except the Fed. And I don't think the Fed remains for reasons that are consistent with all the cases where the administration has been mowing down the other agencies. So, right now they just said, that's its own kind of, has a history of very unpersuasive reasons. But what are they going to do? Are they going to, in fact, impose the mortal blow on the Fed? Not just what they might think of as these but the Fed. And that's what's really hovering here. So for now, whereas in every other case, they gave the temporary relief that let the United States run amok, here they say, we will take this up in February. They don't want to do it by the shadow docket. And of course, no dissent here. Progressives are like, fine, don't do it. We're not going to write an opinion that says, you're being patently inconsistent with what you've done in other areas. But guess what? They're being patently inconsistent with what they've done in other areas. And mainly, I think, because of the practical consequences of saying the president can just play spoil system and loyalty games with this agency as it has with others. So we won't know until February. Cook's claim, for starters, of no cause will be heard, and probably a very strong indication of whether they're going to have the courage of their conservative convictions and get rid of the Fed too, or whether they'll, flinch, which would really, in a way, bring the entire line of cases that they've been falling into some, doubt or suspicion if it has this override for the Fed just because it's the Fed. So that's the interesting and important issue that basically is, will the Supreme Court complete its total demolition job of independent agencies, or will it flinch when it comes to the Fed? Stay tuned, but nothing happens till February when the case gets heard, and then and only then, in contrast to how things have gone in other areas, will the court entertain motions about the potential or arguments about the potential unconstitutionality of the Fed. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.